Let me note that we have a class website. I put that in the class email I send out to those who wish to be on the mailing list. If you wish to be on the mailing list, please send me a note to stovermw@gmail.com or leave your information in the chat box and I'll grab it from there. But you can also send it to me offline. I want to thank Ellie and Jim Monroe for being our coordinators today. They are top notch, and I appreciate them. This would be impossible without them. I do encourage you to either get a hard copy of the Constitution or use the ones that are available online for free as reference documents. We began year 2021 with one of the most progressive national administrations in recent history and a federal judiciary that has been substantially made over to reflect a conservative judicial philosophy by appointments made by our former president and confirmed by a majority of US senators. And because of 3 presidential appointments during his term, the term of our past president, we have the most judicially conservative Supreme Court in probably more than 60 years, So don't be surprised if there is considerable conflict in the courts between the branches of the federal government in this year and subsequently. In this course, we will review the historical and contemporary interpretations of the constitutional speed bumps and protection of rights set forth in the US Constitution. Each class will include presentation, discussions, and background videos. Today is February 10th. It is approximately 10 o'clock in the morning. Events, I'm sure, will overtake us. And that's why I say the time. Let's start with this. Every civil officer in the United States and every takes an oath of office. The president takes this oath of office. And why is that so significant? Why do I begin with that? Well, I begin with that is because we hold allegiance to the Constitution, not to any one official, not to a head of state, but to a form of government set forth in our Constitution as amended and interpreted over time. Now, in the United Kingdom, very much a democracy, civil officers hold allegiance to Her Majesty the Queen. I mean, if there's a better comparison between the US and the UK than this, it's hard to imagine that we swear to the Constitution. That's why the Constitution is so important to our form of government. I remain a part-time, really basically a volunteer civil officer in the city in which I live in. And I take an oath even as a municipal official to the Constitution of the United States, as well as the Constitution of the state of California. So what is this course about? Well, you know by reading the Blue Book what it's about. We talk about the operating system of the world's longest enduring republic. That's the Constitution, our operating system. In this class, we'll talk about the words and meanings of the Constitution and the limitations on the president, Congress, and the states under the Constitution. We'll take some items right out of the headlines and examine the constitutional principles behind those issues. and will consider from time to time proposals to change the Constitution. I use a number of sources because I'm not an attorney. I use a number of sources to make an informed presentation to you. Number of podcasts and as well as publications. The We the People series from the National Constitution Center is excellent. Washington Post has two. Can They Do That? Which is an ongoing series, and a constitutional history one called Constitutional that I highly recommend. My primary sources are these, with a big emphasis on the National Constitution Center. National Constitution Center is located in Philadelphia, in the Liberty Square area. It's at the other end of the mall between the Independence Hall and the National Constitution Center. One of the justices of the Supreme Court is always one of the co-chairs of the National Constitution Center. If you're ever back in Philadelphia, I highly encourage you to visit it. It's a fascinating place. It tells you how to interpret how the Constitution is interpreted, and their website is excellent because they have scholars, both scholars who take a more progressive view on the Constitution and those that take a more traditional view on the Constitution, kind of help explaining many of the portions of the Constitution and the remaining and enduring debates over the Constitution. In reflecting on what we present in this class and the sources I use, always remember there's more sources. The use of more sources is a good way to better understand an issue. Take this class as one of your sources, but not your sole source. So let's do a little bit of history. This is the room in which it was, in which it happened. This is Independence Hall in Philadelphia. In this small room, the Constitution was framed. Imperfectly, but majestically framed. And the National Park Service is happy to give you a curated highlights of the room and its place in history. But the framers had a number of choices of how they might structure the American government. And they reflected upon what Aristotle said about the basic forms of government. One that would have one ruler, that he thought a monarchy made sense, but unless it becomes tyrannical. He thought a few rulers might make sense as well, but it could lead to oligarchs and a plutocracy of the rich. And he saw advantages in direct democracy, but he saw that direct democracy can become and can degenerate into anarchy. The English Bill of Rights is a very important foundation to the Constitution. Even though it only establishes rights for a small percentage of the population in England at the time, it set forth many of the provisions that carried over into the American Constitution, particularly in the Bill of Rights. It included such items as the right to petition, the freedom to bear arms, freedom from cruel and unusual punishment and excessive bail, freedom from fines and forfeitures, freedom to elect officials. let's go through some of the constitutional principles of the American form of government. And we're going to have a period in a few minutes in which we'll kind of come back and answer questions. The framers of the Constitution wanted a government stronger than a union of sovereign states that existed under the Articles of the Confederation that were used during the Revolutionary War and thereafter to bind the states together. Basically, every state had a veto. And it led to a lot of deadlocks, and particularly on matters such as taxation. It led to, you know, a government that was excessively weak. The framers wanted a powerful enough government, but not too powerful. They certainly didn't want a monarchy. And they wanted to both prevent a tyranny of the few as well as a tyranny of the many. So they came up with a concept by the way they negotiated the Constitution of a mixed regime that had checks and balances as a central feature and power sharing between the central government and state governments. So checks and balances within the national government and power sharing with state governments and the national government. A key element of our constitutional framework is that the framers set forth that the national government would have limited powers that are delegated and enumerated in the Constitution, while state governments would have general powers, generally also called plenary powers. That is, that the constitutional powers would be set forth, while state powers would be considered traditional governmental powers and did not need to be enumerated in the Constitution. And the Constitution set forth a government in which the supreme power is vested in their people and their representatives, not in any one person or any lineage of people, such as a monarchy. So let's talk a little bit about the checks and balances in our system. Each central government branch checks the power of the other two branches. That is the executive, the legislative, and the judicial branches. And the Bill of Rights that were added in order to ensure the ratification of the Constitution, and were not in the original document, but were promised to be added, and were added in the first Congress of the United States under the Constitution. And thereafter also through a great expansion of constitutional rights that applied then also to the states through the 14th Amendment, were specific limiting powers and an additional check and balance. The judiciary has exercised judicial review powers that were not expressly set forth in the Constitution, but has become another check and balance on governmental powers. And it seems like everything is limiting, and that's the point I want to make today. Governmental power is further limited through the division, or concentration of power is limited through the division of authority. The chief executive, that is the president, or oftentimes referred to as the chief magistrate, is selected by the states through an electoral college. We'll have a short video on that in a few minutes, for a fixed term and subject to congressional removal. So chief executive, electoral college, subject to removal. Judges are nominated by the chief executive, but must be confirmed by Congress. Congress, the upper house, in this case, the Senate. By the way, it's called the upper house because during the first Congress, and until the seat of government was moved, the upper house was, the Senate met on the second floor of the federal building in New York City. And it's got the name the upper house. By the way, the doors were locked and you couldn't get into it. The public couldn't get into it. They could get into and observe the House of Representatives, however. So governmental power is checked by the division of authority and balanced by a selection process. Even in Congress, you have two branches of government, one checking the other. You have to get legislation through each house, and in some cases, some specialization. The Senate confirms key appointments. The House initiate bills regarding money and taxation. The president is checked by the Congress. The judiciary is checked by the appointment powers and the pardon powers of the president, and the confirmation powers of the Senate, and are subject to impeachment and removal, just as a civil officer. And federalism, that is the division of authority between national and local and state government, provides the final check. No matter how you describe it, we have a government that is designed to not become excessively powerful, but hopefully a government powerful enough for the times. That's been the great challenges through American history. Is the governmental power checked enough, or is it too much checked to be effective? President can be removed not only by impeachment, but also through disability, through the 25th Amendment. The impeachment and removal process that we are very familiar with in our recent history, because in our times, we've seen 2 of the 3 uses of impeachment against a president have occurred in our times. Mr. Clinton's and Mr. Trump's were impeached, but were not removed. And the other person in American history, of course, was the non-Lyndon Johnson. We make it very hard, however, to remove an officer, in this case, the chief magistrate, selected by the Electoral College. Requires a 2/3 vote and a trial removal by 2/3 vote based upon articles of impeachment, setting forth how the person violated the provisions of the constitutions. Let's quickly review federalism. Federalism is the division of powers between the national government and the state government. For example, who is responsible for public education? For the most part, state government. Who conducts elections? State governments. Who provides, law and order, police authority? Well, they both do, but most actions at the state and local level. Who conducts diplomacy with other nations? The national government. Who provides for common currency? The national government. The national government, however, only for about the last 150 years. Before that, a variety of currencies circulated in America, who provides for an armed forces, the national government. So a division of power and also of functionality between the national government and the state government is one aspect of federalism. The other aspect is the federal government is supreme to the states. And we'll go through the supremacy clause of the Constitution in a few moments. Okay. Constitution has two provisions that guarantee federalism. One is the 9th Amendment that reserve powers not enumerated in the Constitution to either the states or through the 10th Amendment to the people. Article 6 of the Constitution establishes that the Constitution, federal laws made pursuant to it, and treaties under its authority constitute the supreme law of the land, and thus take priority over any conflicting state laws. That was a major feature of is a major feature of the Constitution, and was a major hurdle to get the Constitution ratified. Now, here's a funny thing, not so funny. A year ago, progressives would say, how do we constrain the current administration, the Trump administration? Conservatives are now thinking, how can we constrain the Biden administration? So the Constitution, how you see federal issues sometimes are, as they say, where you stand is where you sit, or who controls the branch or a government that you are concerned about or you're supportive.
I have one question, Mike.
Yes.
Can a member of Congress be impeached? I'm thinking of Georgia and QAnon lady.
No, the answer is no. Nor can they be arrested on their way to and from Congress, because that was what the English did for a while. They would arrest parliament members. Look what's happening in the Miramar Republic today, in which they
so if you can't impeach them, how do you get them out? There's some other mechanism.
There's two mechanisms. Of course, the fundamental mechanism is you vote them out of office, but the other mechanism is that the Congress can expel a member, and that's generally, though not exclusively, the Supreme Court has limited that a little bit, but basically by action of that House can exclude that member. Now, I think former Congressman Adam Clayton Powell, now deceased, I think was removed 3 times and got reelected and came right back again in the special election.
Okay.
Ellie, I'll let you do the recognition.
Thank you. Marilyn Wasserman, please.
Yes, I had a question regarding the state's conduct of elections. Suppose it is for federal office, the representative, Senate, and President of the United States. Does the federal government have any role then in ensuring that the people are not discriminated against? For example, establishing that in all states, it will be possible to vote by mail.
Well, that's an interesting issue that the federal government has exercised both in the Voting Rights Amendment that exists in some form still, but was very much limited by the current Supreme Court, and by setting a national election date. It's be hard to imagine now, but when John Adams lost to Thomas Jefferson for the presidency, that election process started months before it ended. I mean, people were, electors were voting in some states and not in others until later. So can there be a national vote by mail for federal officials? That's an interesting question. I don't know. But the federal government probably could have a separate election process, but that would be very cumbersome, I'm sure, to do.
Thank you.
Thank you. Claire?
Just a question, Mike. Do you think that this course now will discuss equity and equality?
Well, I have 19 issues. I think this court will make landmark decisions in the next 4 years, and I'm not sure I put that on the list. But when we get to the list, so maybe we add a 20th one. I think this court is going to make a number of landmark decisions because there is, just as the Warren Court had a clear progressive majority, there is a clear conservative judicial philosophy majority on this court. You can have one or two members vote with the or you can have one vote with the progressive and still have a solid majority.
But the words, I mean, the semantics with it, I mean, you know, they're so diametrically opposite.
Yes.
To try to, I just wondered if you'll be talking about that during the course.
Well, we'll be talking about constitutional interpretation in a few minutes, and words matter. Words matter a lot in constitutional interpretation.
Thank you. Marlene Burnett?
So I'm curious, I saw your slide, it was about impeachment, and it said that 2/3 majority, I believe, in the Senate is required to not impeach, but get somebody out of office, but a simple majority to prohibit them from being in another election. So does one have to preclude the other?
Yes, the removal is generally considered. We'll see because we're in interesting constitutional territory now. But generally, I think the view is that the predicate or the key act, you first have to find the officer guilty of the article of impeachment before you can move to the punishment. Obviously, one punishment is removal from office. The other punishment can be, in effect, a lifetime prohibition from holding office.
Thank you. That's what I thought, but just wanted clarification.
So let's talk a little bit about the three branches of government. I would imagine everyone knows, but let me recall for you. We have the legislative branch, which is Congress, 2 houses. We have the executive branch, which is the president and the vice president, and the judiciary, the Supreme Court and other courts appointed by Congress or established by Congress. The legislative branch, the lower house, the House of Representatives, upper house, the U.S. Senate. The congressional powers are very much explicitly identified in section 8 of Article 1, the so-called express powers of Congress. And it ranges from, to coin money, to establish post offices, grant patents and copyrights, create courts inferior to the Supreme Court. That is, you don't have to amend the constitutions to create, as they did, appeals court or a patent court or a tax court or a court of military justice. It had many provisions of Section 8 had to do with the war powers of Congress. Most of these congressional powers would not surprise you. So I just note that these are the so-called express powers. But there's implied powers, and implied powers require Supreme Court interpretation or court interpretation, and they can change over time. Implied powers are a power that arises from an express power. You have a general right to do something, but it doesn't say that you can do X, but Y is very much related to X and is a contemporary form of X, and therefore is implied and that you also have that right. The implied powers are come out of are interpreted as powers of Congress through what's known as the necessary and proper clause of Section 8. That is, the Congress can make laws that are necessary and proper to carry out their express powers, or the elastic clause that these powers over time have just grown. For example, the congressional right to regulate interstate commerce has been used for issues that many conservative judicial thinkers believe have gone well beyond the regulation of commerce. And two examples that are used in almost every history textbook on the Constitution on how implied powers were manifested themselves in the early days of the Republic. Establishing a national bank in 1791, there was nothing that said in the Constitution that you could create a national bank, but the court interpreted that an act of Congress was constitutional in doing so. And when President Jefferson proposed the Louisiana Purchase, there was nothing that said in the Constitution that explicitly provided that right. And of course, this is where a lot of these implied powers are, where there's a lot of litigation that will be enduring in our republic. Is that a legitimate implied power, or did in previous judicial interpretation, was it too expansive or too limiting, or did the Congress is the Congress right in exercising it? House of Representatives elected every 2 years, based upon districts established by the states, but are based upon a national census every 10 years. One just was completed, though the numbers have not yet gone to the states. All revenue bills must originate in the House of Representatives as well. And that's something, the constitutional principle that the representatives are there to guarantee the public purse. Very limited standards for members of the House. I mean, 25 years old and be a citizen for 7 years. The citizenship requirements primarily based upon where the Republic was at the time of the Constitution formation. There was a fear that English or in some cases French would come over and try to become a significant portion of our government. So you have these citizenship limitations. Of course, Alexander Hamilton was limited from being president by not being by being foreign born. The Senate elected every 6 years in groups, so 1/3 every 6 years. I mean, every 2 years for 6-year terms. Until 1913, senators were chosen by state legislatures. And it was only through the 16th Amendment that they were decided to elect them by popular vote. By the way, by that time, many of the states had changed their constitutions to allow the people in their states to identify who should be the US senators representing those states. 2 senators per state, regardless of population. Wyoming has the same number of senators as California, despite the fact that Wyoming only has one US representative by population. We have over 50 by virtue of population. The Senate has to approve many presidential actions, treaties, cabinet officials, military flag officers like generals, admirals, and designated high federal officials. For example, the head of the CDC does not have to be confirmed by the Center for Disease Control, does not have to be confirmed by the Senate. However, the head of the FDA, Food and Drug Administration, does, and it's based upon how those entities were established over time by federal statute. Generally speaking, the Congress can establish which officers require Senate confirmation. And of course, Supreme Court nominees must be confirmed by the Senate, now by majority vote. Senators must be at least 30 years and be a citizen for 9 years, kind of fairly modest requirements. The second branch of government, the executive, president, vice president, though Dick Cheney one time argued that he was part of the congressional branch, legislative branch, in terms of one legal dispute. To be president, 35 natural born citizens of the United States. Many of the people in the Constitutional Convention hated Alexander Hamilton, or hated the fact that he was from New York City, not the first New York City resident to face that bias, or from banking interests in New York City. Reside in the US for at least 14 years, 4-year term. Since 1951, a constitutional amendment, president can only serve 2 terms, though they need not be consecutive. The president is the head of the executive branch, and that is a subject of considerable judicial controversy now. Not that the president is head of the executive branch, but is the president empowered to make all the decisions in the executive branch, even those that delegated by Congress to individual agencies of the executive branch? We'll get into the fine points of that perhaps in a different class. The president has those powers you would expect the president to have. Appointment of members of the executive branch, commander-in-chief of the military, head of state. We don't have a queen as the head of state. We don't have an officer of the government as the head of state. France has both a president and a prime minister. The United Kingdom has a queen and a prime minister. Israel has a prime minister and a president. Germany has a chancellor, which is prime minister, and a president. We consolidate those into one office. I have a short video on the Electoral College and why it is. And I thought maybe I'll show that because right after an election, if your guy won, you're happy with the Electoral College. If your guy lost, or gal, sometimes you're not. Let's remember why there is an election. And for that, I'm going to have to switch screens. So hold on here.
To the Scholar Exchange. Today's topic is all about the Electoral College. Find out about its controversial origins at the Constitutional Convention, how James Wilson plays into this conversation. Then we're going to dive into, over time, what is the history of presidential elections in America and current constitutional questions around the Electoral College and Supreme Court cases like the faithless electors case of June 2020. Find out more in today's session on the Electoral College.
Let's start with the original Constitution, Article 2, Section 1. So that says, each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed and elected.
If you're looking at how this works today, there are a total of 538 electors in the Electoral College. The states are given the number of electors equal to their congressional delegation. So if your state has 2 members in the U.S. House of Representatives, 2 senators, it then has 4 electoral votes in the Electoral College. Today, the American people vote for president and vice president on election day. We'll do it again in November, although many of us may also be voting by mail. But these votes, technically speaking, don't directly determine who's president. There's another step beyond that. So technically, the votes on election day determine which electors will be appointed into the Electoral College from each state. And then those electors themselves actually do meet physically in December after election day to cast their votes for president and vice president. If a candidate receives a majority of those Electoral College votes, she wins the election. Even if she lost the popular vote, she wins the election because she won a majority in the Electoral College. But if no candidate secures a majority in the Electoral College, the election's then sent to Congress. And this happened in the election of 1824. That election was decided in the U.S. House of Representatives. So when this happens, the U.S. House of Representatives, voting as states, not as individual members, picks the president, and then the Senate selects the vice president. So the Electoral College itself, it doesn't really, as a practical matter today, function as a deliberative body. When those electors meet in December, they don't really discuss the candidates. It ends up being a pretty mechanical, technical thing where they will cast their vote for president and vice president. Under the Electoral College today, 48 states appoint all of their electors on a winner-take-all basis. So if a presidential candidate wins California, even by 1 percentage point, or Pennsylvania wins it by 1 percentage point, it receives all of the electoral votes for that state. That's in 48 of the states. Finally, there are 2 states that are outliers today, Maine and Nebraska, award electors by congressional district, by popular vote in each congressional district in those states. And then finally, award the final 2 electoral votes based on who wins statewide. That's just a bit about the basics of how the Electoral College works today.
So how does the system work under the original Constitution? Each elector votes for 2 candidates. If a candidate gets a majority of electoral votes, he becomes the president. The person in second place becomes vice president. If no one gets a majority in the Electoral College, the House of Representatives decide the election, but the House doesn't vote individually, but instead by state. So that addresses the concern of some of the framers from small states who are afraid that the large states will dominate and demand equal state voting. The role of the House is crucial because many of the framers expected that the House would decide most of the presidential elections. In other words, the Electoral College would fail to agree on a president most of the time. No one would have a big enough national reputation to get a majority of the electoral vote. And their best guess is the Electoral College would winnow the candidates down to the 5 highest vote getters, and then the House, voting by state, not individual, would actually choose the president, and then the Senate would choose the vice president. So in this view, the Electoral College would limit but not eliminate a legislative role in selecting a president. As Mason put it, the electors would fail to generate a first-round majority winner 19 times in 20. So that's really interesting, isn't it? In practice, far from expecting that these independent, thoughtful electors are going to actually choose candidates, the framers think in most cases they're not going to be able to agree on any candidate by majority, and they'll just winnow down the best ones and then send it to the House, and the House will decide by state, and the Senate will choose the vice president. But it clearly was a very complicated system trying to balance these competing needs of limited information and a fear of partisanship.
Let me just stop that video there in the interest of time and move back to our central presentation. Isn't that interesting? It wasn't that one of the framers, George Mason, thought, hey, that Electoral College is just a willing process. No one will know in this expanse of America, these office holders or these prospects for office holders after George Washington and Thomas Jefferson, the big names, are off the field of play. Well, it didn't work out that way for the most part. The judicial branch of government, Supreme Court, and inferior courts established by Congress, inferior to the Supreme Court, not inferior of inferior people, but of inferior jurisdiction. Supreme Court, the highest court, nominated by the president, confirmed by the Senate. No age or citizenship requirement. Only branch without citizenship requirements. Didn't think the framers in large measure didn't think the Supreme Court was going to be a big thing, or at least you can make a good historical argument. They didn't think it was going to be a big thing. Served for life unless removed by Congress through the impeachment and trial process. Jurisdictions of the court set in the Constitution and by acts of Congress. So the Constitution set forth certain jurisdictional areas such as disputes among states, but allowed Congress to establish jurisdiction for the court in other cases. For example, the Supreme Court has established its own jurisdiction in some places. The Supreme Court, I think last year, ruled that they had no jurisdiction or should have any jurisdiction over cases regarding reapportionment unless they dealt with fundamental liberty rights, such as an apportionment of congressional districts by race. That would be a fundamental liberty issue. But in terms of the political process, they took the view that that's not subject to the jurisdiction of the court. But here's the big thing, the big takeaway. Judicial reviews of acts of Congress. Initially, a point of view was taken, though some Federalists disagreed and took the position that, yeah, the judiciary review of acts of Congress and acts of the president were subject to judicial action. Others said, no, this was never, if that was going to be the case, it would have been explicitly set forth in Article 3. And each branch under one view had a check and balance on the other one. The Congress could negate unconstitutional acts by the president by his censure or removal, impeachment and removal. The president could, through his veto right, could in effect declare an act presented to the president as unconstitutional by his veto power. So let's, this is the supremacy clause of the Constitution. This Constitution, all laws shall be the supreme law of the land, and the judges in each state shall be bound thereby, the so-called supremacy article. Okay. So in summary of the constitutional principles, the Constitution creates a government that puts the power in the hands of the people, the ultimate hands of the people, or those who wish to be a little bit more precise would say, well, as it's in the hands of voters, and the voting franchise was very limited at first and only expanded over time. Separates the power of government into 3 branches. It sets up a system of checks and balances. It divides powers between the federal and state governments. It describes the purpose and duties of the government, but provides it narrowly for the national government and expansively for the state governments. Prescribes the system for electing representatives. Establish a process for how the Constitution is ratified and subsequently amended, and outlines some but not all rights and freedoms of the people. The reason why there wasn't an explicit Bill of Rights in the Constitution as sent to the states for ratification was because of the dominance of the argument. At least I believe this is the case, looking at the historical references, that the framers didn't want to limit the rights delegated under law to individuals. They were afraid that if you said you have the right of religious exercise, but you didn't say you had the right of free speech, that you might interpret that fact that it wasn't explicit in the Constitution, you didn't have that inherent right. And that's been a battle over the years. And the political process made the made the supporters of the Constitution take an initial Bill of Rights as part of the promise that through the ratification process.
How is it that deeming a cabinet official simply acting, the acting secretary of fill in the blank, makes it such that Senate approval is avoided?
Well, yeah, that has been a subject of law. That is law passed by Congress, approved by the president over time, and judicial interpretation in terms of who is acting. And there is a provision for acting appointments or recess appointments when the Congress is not in session. Though in recent years, Congress has made sure that they are in session all the time to avoid the other to avoid the executive sneaking in appointments, including to the Supreme Court through so-called recess appointments. But it's set forth in statute, and it can be undone by changes in statute, but probably unlikely to have major changes. And someone has to be to be an acting secretary. Oftentimes they have to, and most times they have to have been previously confirmed by the Senate in at least some other position during their current service. So a U.S. attorney that is subject to Senate confirmation could serve as, I believe, as Attorney General, but someone who was a law school professor who had never been, or a state Attorney General who had never been confirmed by the Senate for any current position could not be. So it's just the way the law operates.
All right, thank you.
Regarding the requirement that congressional representatives be U.S. citizens for a specified number of years,
Yep.
How did that work for our early members of Congress?
Well, they just made sure that I mean, it was no doubt negotiated as part of the Constitutional Convention what would work, but remember,
the question is,
by the time
not some of our members of Congress directly from Europe, from England, they weren't born here. How did they become citizens?
oh, they became citizen because they were here.
Okay.
And it wasn't, and it, the first 50 years of American history, maybe even beyond that, there wasn't really any immigration laws. So that the Constitution was created and ratified about almost 10 years after the founding of the Republic, so that the people who became the first members of Congress had been around for a while, so they could easily meet the residency requirements. Thank you for your question. Common mistakes about the Constitution, according to a publication put out by the American Bar Association, the ABA. I didn't misspell ABBA. This is the American Bar Association. Most voters today, through public opinion polls, would miss such concepts as most voters today would not have been voters. Would not have qualified as voters at the time under the historic times in which the Constitution was first ratified. That is, they weren't property owners. Many states required them to be property owners. Of course, few states, so some allowed emancipated slaves to vote, and then some states removed that over time. And then, of course, you add the indigenous population and women, and it was really a fairly small amount. And by the way, some of those original elections were all done in public. It was really widespread. Secret ballots started to occur around the time women got the right to vote. It was not uncommon that people would actually go out and get beat up for voting, for announcing for one candidate or another. That's what, I mean, wasn't that common, but it occurred. Wasn't uncommon, I guess, is the term I want. Many of the rights we enjoy today were not originally granted. Yeah, people mistake that. We didn't have yet. Most of all the restrictions in the Constitution was on acts of Congress. The Congress shall not pass an act. It wasn't until the 14th Amendment after the Civil War that, and by extension of that provision by the courts, to limit state action. So states had at the time, some states had at the time of the Constitution, a state religion, an established state religion that was lawful under the Constitution initially. We talked about before, framers believed a Bill of Rights was unnecessary because it would either be too limiting or redundant of rights granted in the state constitutions. And they cited back that English Bill of Rights as an example of those were just assumed that everyone would have, at least in the American context. And the Bill of Rights was not a bill, it was a series of amendments that occurred following, proposed to the states by the first Congress and ratified, though not all of them were ratified. Matter of fact, the First Amendment on the freedom of speech and religion was not the First Amendment sent to the states. It just happened to be the first one that was ratified. Neither democracy or God appears in the Constitution, but religious freedom is guaranteed. And as I said, the First Amendment was not, had no greater place in the amendment sent to the states than any other amendments. It just happened to be the first to be confirmed by the states. Okay, let's move on. Let's talk about judicial review. This is really big. This is a big concept. And this occurred after the Constitution. As a matter of fact, it occurred in 1803. That's my crib note because it's right there on the marble wall of the Supreme Court. In Marbury versus Madison, the Supreme Court asserted its jurisdiction to declare acts of Congress unconstitutional. That was not as clear cut as you might think. So let's look at it, and I have a video on that.
The Constitution spells out the model of separation of powers in the first 3 articles of the Constitution. It also spells out how checks and balances function to protect the freedoms of American citizens. Now let's see this system in action by examining some real events from American history. Let's take it all the way back to the early 1800s. President Thomas Jefferson had just taken office, and he has some problems with several officials that his predecessor, John Adams, appointed before the end of his term. One of them is a man named William Marbury, who Adams made a justice of the peace. Jefferson tells his Secretary of State, James Madison, not to deliver Marbury's commissioning papers, which basically means Marbury can't start his new job. Marbury takes his case to the Supreme Court. He believes that the Judiciary Act of 1789, a law passed by Congress, gives the court the power to order Madison to deliver the commissioning papers. So what does the court decide? The court, under Chief Justice John Marshall, agrees with Marbury that it was illegal to withhold his papers. However, they also find that they themselves do not have the authority to compel Jefferson or Madison to act, that it's beyond the scope of their power as outlined in the Constitution. The Supreme Court declares that the Judiciary Act of 1789, the law that Congress had passed giving them that kind of authority, is unconstitutional and therefore null and void. Looking back, this was an important moment for the Supreme Court. The case established that the court had the power to throw out laws passed by Congress that they found were unconstitutional. This power is known as judicial review, and it's a big check that the court has over Congress.
So so the Chief Justice John Marshall, by cleverly deciding that saying that the power Congress gave to the judiciary to enforce the ability to make this appointment happen was unconstitutional. So instead of striking down what Thomas Jefferson wanted to do and what he probably could convince the Congress to do, Jefferson got what he wanted, but John Marshall expanded tremendously the powers of the Supreme Court. In other words, it took it from almost a backbench or a part of the Constitution to a key player. And when the other two branches are deadlocked in direction, which we've had in many ways for the last 20 or 30 years, between the legislature held by one party and the executive held by another party, the Supreme Court has been a major player in sorting out issues that probably in many cases would have been best left to Congress and the executive to decide. However, there is a downside to judicial review. And the downside to judicial review is one, of course, it's not stated in the Constitution. Two, it can substitute, in the view of some, non-elected judges for taking the role of elected officials that should be making laws. But the court was very sparing on the use of judicial review. And after Marbury versus Madison, it wasn't done again until this case. And let me show you this case that probably helped trigger the Civil War.
Constitution Center presents Constitutional Questions with Supreme Court Justice Neil Gorsuch, the Dred Scott case. Dred and Harriet Scott were enslaved people whose owner had once taken them to live and work in territories where slavery was illegal. Later, Scott sued for his freedom, arguing that any enslaved person taken to a free territory automatically became free and could not be re-enslaved. In 1857, his case made it to the Supreme Court. In a 7-2 decision authored by Chief Justice Taney, the court concluded that African Americans, whether free or enslaved, couldn't be United States citizens, and therefore they had no right to sue in federal court. Taney also wrote that African Americans had no rights which the white man was bound to respect. The decision also said that Congress had no power to prohibit slavery in the territories, that slaves were property, and that slave owners could not be deprived of their property without due process. The decision declared that the Missouri Compromise, passed decades earlier to balance the power between slave and non-slave states, was unconstitutional. Instead of settling the issue of slavery, the Dred Scott decision sped the nation's path to the Civil War. And now, Supreme Court Justice Neil Gorsuch.
So we had Marbury versus Madison, and then we had the Dred Scott decision that showed the limitations of judicial review. In summary, the case against judicial review is not an express power granted by the Congress. However, Hamilton argued for it during the Constitution's ratification in Federalist Paper number 78. It is the federal judiciary's greatest power, but the Dred Scott decision showed that it, when used imprudently, by declaring the Missouri Compromise unconstitutional, it attempted something that the political branches of government should have tried to do, and I think also was morally wrong. So let me defer to next time constitutional interpretation, and let's go to the a moment with the Supreme Court. We have a very different Supreme Court now than we did a year ago. Actually, a very different one we had 3 months ago with Justice Barrett now on the court. That is a very solid 6-3 judicial philosophy of conservative values now in control of the court. And in Justice Breyer is, as well as Justice Thomas, are the oldest members of the court. And both have been speculated to retire, though I suspect Justice Thomas has put off his retirement for 4 years. So the court has a number of big issues before it. And there's no reason to believe they won't deal with them. At least, maybe not in this term, but in the next couple of years. They have a series of election issues, not that will not change the nature of what happened in our, or change the results of what happened in our recent election, but they deferred until after the election was over with. They have a number of reproductive rights cases pending before it. They have decided at least on one of those reproductive rights case in dealing with mail order abortion pills that ruled against the ability to do that. Immigration authority of the executive branch, the so-called DACA issue, is before the court. The progressive People for the American Way organization is very concerned about where the court may go this year or next. Conservatives, I would say, are very concerned that the court won't go these ways, and hopeful that they will go against what they have done in the past. There are challenges to the Affordable Care Act still before the Supreme Court. Limitations on the power of executive branch agencies and so-called independent agencies, so-called administrative state limitations. Whether or not the president is the ultimate power within the executive branch, even when the Congress gives some power to individual agencies and not expressly to the president, so-called unitary executive doctrine. Immigration enforcement discretion, same-sex marriage and other gender-oriented and orientation-oriented issues can come back to the court and be refined by the court, and will probably be refined. Gun owner rights, I think we haven't seen the last of this issue before the Supreme Court. Supreme Court has punted on a couple recently, but I think they'll return and expand gun owner rights. I'm not saying that's a good or a bad, I'm just thinking that's what's going to happen based upon the present makeup of the court. Racial preferences in higher education admissions. I would think that's on almost life support now, based upon the new court supermajority. Powers to limit the executive, the presidential powers. Be interesting to see how the court may rule in a number of cases brought against the past president in terms of the enforcement of actions. The Supreme Court seems to be moving in the direction of limiting the right of lower courts, lower federal courts, on doing nationwide injunctions, or they appeared to be prior to the election. Whether or not they'll continue. Recently, a Texas judge did a nationwide injunction against the in terms of border enforcement and deportations. Congressional oversight limits. There's very few cases defining the power of Congress to supervise the executive branch. It could very well again come up, maybe less so as long as Democrats are in the Congress and Democrats are in the White House, But as soon as one of those houses change, I think the cases will get right back to the Supreme Court, and the Supreme Court may pick a case, may draw a case to express their view even ahead of time to limit the power of Congress. Or they may not, they may expand it. I think it's more likely the former than the latter. The exercise of religion protection, I think, is going to be rife with a number of decisions in the next 2 years. First Amendment cases are, call me Supreme Court, they get so many, and judicial opinion based upon First Amendment or dictum on how to decide these type of cases might be changed through the current Supreme Court. The right of privacy, not in the Bill of Rights. It's maybe exactly what the framers were afraid of. If you are explicit in the rights of specified in the Constitution, that you may be too limiting of rights. The courts have interpreted an implied privacy right and used that in a lot of reproductive rights cases. But others, conservative judicial scholars say, I don't. If people want that in the Constitution, they should amend the Constitution to provide it. Limitations on the right of the federal government to regulate business and personal action through the Commerce Clause. I think we're going to see a lot of important action here, and I think the court is going to be more limiting than in the past. That is, more limiting on governmental action and more expansive of business action. Criminal trials and imprisonment issues, another area that courts deal with almost in every session. By the way, every session of the Supreme Court, every year, every term, there are 70 to 80, only 70 to 80 cases that the Supreme Court does a full briefing and hearing process. Only they can issue a number of orders, but the big cases, usually they only take 70 to 80 a year. Criminal trials, imprisonment, state rights claims under the 10th Amendment, that seems to be one of expect states like Texas and other states with a strong Republican majority in the executive branch and the Attorney General to seek expanded state rights and to avoid federal actions of the administration. Justice Thomas wants the court to look at the libel laws to make newspapers more subject to lawsuits, such as they are in the United Kingdom. Just look at the New York, Times versus Sullivan, or Sullivan versus New York Times case, for example, limiting that. Eminent domain limitations. The court was very narrowly decided that state and local governments could exercise eminent domain rights under certain conditions, but seemed to want to go further than in limiting those rights. I think we're going to see them going further in limiting the rights of state and local government to take private property without fair compensation, or defining what is fair compensation, defining what is a taking is. But the court oftentimes just comes down to the narrowest issues, such as this one that is being argued in the court now, just very narrow issues, whether copyright protections extends to a software interface, and whether the jury found the use of the interface in the context of creating a new computer program constitute fair use, just interpretation issues. So some of the 70 or 80 cases are just basic law. Okay, let's go down to, there was a question at the beginning. What about, is the impeachment trial, the trial on the impeachment charges, constitutional or not? Well, guess what? Generally speaking, there's two sides to this, and and you're going to hear that argued. States did try former officials in impeachment and removal and actions even after they left office. There's a precedent for federal action along these lines. On the other hand, you can argue common sense that if a person's already out of office, why do you do a proceeding to remove the office person? And the common sense, well, if you can't do that, then can you just do everything at the last moment and never face any sanction through constitutional law? So I'll put some things on the website to help clarify this issue. I know it is of interest to you all. So I think while we have a lot more we could go through, and we will go through in subsequent classes, we're at the end of this class time. Okay, thank you all. Thank you very much. Remember, we have a class notes website. We also have a mailing list. If you want to be on the mailing list, you don't have to be on the mailing list. You don't have to go to the class notes. Send me a note on suggestions or to be on it. My email is stovermw@gmail.com. It's in the blue book as well. So if you don't hesitate to stay in touch. Thank you very much. I enjoyed doing the class. I really appreciated your participation today, and you'll have more time to participate in future classes.
Nicely done, Michael.
Good class. Thank you.
Thank you.
Thank you.